You doing that now? Okay, cool. All right, good morning, everyone.
Morning.
All right, it's cold outside, but it's warm inside.
Yeah.
Yes. Today I have a privilege to have a good friend of ours, Harry. He's a well-known attorney in the community. He also helped us on some of our legal on commercial contracts and things like that. But today we're going to talk about something that's I'm personally very interested because in life, two things are certain. Texas and exactly. So we don't talk about that, right? Oh, no, we're not talking about that. We're not talking about taxes, but it's kind of related. What Harry is gonna share is kind of related, right? Because what happened, like what's the planning after you pass away and things like that, and what are the from a realtor standpoint, what are the opportunities and things like that. But with that said, I mean, Harry, we're all here for you. Just want to learn a lot from you. So
thank you, Calvin. Yeah, so again, I want to thank Calvin and Daniel for inviting me here today and allowing me to speak to you guys. I really appreciate you guys coming in and listening to me. So our topic today is estate planning, and it's our title is very up there and big. The shocking truth about estate planning, what your clients need to know, and how it can boost your business. But in truth, it can. The more we know about this area that we don't really like to talk about, it's a hard subject to broach between your family, between your spouse. And it's just one of those things that we don't like to think about. But we will talk about it today, and I'm really glad that you guys are here today. So a little bit about myself. Again, my name is Harry. I am an attorney here in the Dallas area. So my law firm is Loung Law Firm. We do estate planning, business litigation. I do immigration is primarily where I'm at. I am also a fee attorney for Chicago Title. And so that's how a little bit it ties into this situation, as we'll kind of get to later on in the present, well, in the next slide, basically. So for me here, I've grown up in this Plano area. I went to Bowman Middle School, Williams High School, Plano East. So this is my home. And one of the reasons why I really came back is because I want to come back, give back to the community. That's kind of made me who I am today. Just a little bit, I've known Daniel since high school, so about 10 years. Right?
you wish. Actually, I love you when you're at home.
Okay, so
because the girls used to talk about this guy.
That's live, man. I need you to bleep that one out. It's not going to go well for me. Okay, so what we're going to cover today, we're going to cover wills and trusts, because there is a difference between the two. What to consider when you're doing your estate planning. What is probate? Meaning, what does it mean to go through the courts and to get the will probated? Or if you don't have a will, what does that mean? And we're going to talk about the consequences of dying without a will. So why does it matter for you? So let's take a situation here. You're a homeowner, but you don't have a will. And if you are very much like the typical American that the news likes to portray, you have debts, perhaps a lot of debts. So what does that mean? Well, when you pass away without a will, you will have to go through what's known as intestacy law, meaning I don't have a will, so now we're going to have to go through state law. So how is the state going to divide up your estate? But the problem is you do have one large asset, and it's your house. But the problem is you have a lot of debts that you need to pay for. And those debts, where does that money come from? Well, that money comes from your estate. So if that is the case, then whoever is going to volunteer to be the administrator of your estate will most likely ask the court for what's known as a dependent administration. Now, there's two administrations that you can have. You can have independent, which is free from court supervision, meaning you have basically carte blanche on how to divide up the estate, and you have dependent administration, meaning you have to get the court approval to do anything with the estate. Now, why is that important? If you owe a lot on your debts, you want to have that power of negotiation with the creditors to say, we can't pay all of these debts, so we'll have to go down before we sell the house and satisfy them. But what this does is this creates a very long time frame. So if your client, if your client is the administrator of the estate and needs to sell the house, how does that relate to you? Well, the problem now is if you put that house on market, you will need the court's permission. And if you get a buyer, well, you'll need the court's permission to sell the house. And they will have to explain to the court how this sale price matches the market. Is it better? Is it worse? If it's worse, then you have to do more explaining. And once you get through that process, then the judge has to sign off. So your buyer has to be very patient in this, because you can look at up to 60 days in order to get a hearing, in order to present your case before the court. But that is one of the problems that you have when you pass without a will or without a trust. Now let's get to wills versus trust. And this is really a timeless question. It is, what do I need? What is it that I want to do with my estate? Well, just going down the will section, right? So a will is very simple. I'll put it in quotes because we can make it as detailed or as general as we want. It could be as simple as everything that I have, give it to my spouse. If you don't have a spouse, everything I have, divide it up into quarters, or please give $1 to my son. Please give everything else to my daughter, things of that nature, however you want it to divide out. Now, when we kind of go through the will, you can change it at any time. You can change little pieces of it if you want to. So it is not, and this also goes for most trusts, it's not set in stone as soon as you sign. You can change it as many times as you want, but you would have to go through an attorney to get it officially changed. Now, the bad part about a will is that it has to go through the court. So it has to go through probate proceedings. Now, it's not as intensive as if you didn't have a will, but it does have to go through the court. So what that means is your will is now public record. So anybody can go to the court, pull your file, and see what it is. So there are certain assets in there, and as attorneys, as we've come up through the years, we've realized, okay, we don't need to list every single thing on there, because unfortunately there are a lot of criminals out there now that are just looking for information to target you and your beneficiaries. So we try to limit some of the things that we do put in there, and that's where talking to an estate planning attorney helps, because there are certain things, again, we don't want them to know, or we don't want personal information out there that could lead to any kind of fraudulent transfers or actions. So that is one of the things that is an issue with having a will and probating it. Another one is it can be time consuming and costly. When you probate your will, you have to notify all your creditors. You have to essentially do what's known as a will prove up before the court. So, again, the fastest you're kind of looking into it to get the application through, to get all the citations done, to notify all the people that need to be notified, you're looking at about 30 to 45 days. And then on top of that, you have to set a hearing in order to go before the judge. So you'll have to, whoever the administrator is, will have to testify before the court. And that gets a lot of people nervous as well. But the last time I checked, I believe Dallas County. So if you pass in Dallas County, the next available probate hearing is not until February. So even if you have all your ducks in a row right now, you're waiting till February in order to prove up that will. So this whole time, you can't really do anything with the estate. And so that also creates a problem for the spouse and for the kids, because you have expenses, you have debts that are piling up, you have things that need to be taken care of. This also doesn't shield the assets from the creditors. That's more of a CPA kind of question as you kind of go along in this. So there are certain tax issues that you would have to address depending on how large your estate becomes, and hopefully it's very large. But there's tax complications that may have to be addressed that way. So now as we switch over to trust, well, what is a trust? Well, a trust is essentially, you can kind of think of it as a legal person. It's a person that's holding all of your assets at this time, okay? So if a will keeps everything that you have as yours, and at the end of your life, it distributes it all. With a trust, you put everything into the trust during your lifetime, and you have to maintain that trust. So you have to do all the upkeeping, the adding of trust. If you sell something from the trust, then you have to essentially do it in the benefit of your beneficiary. So there's more work up front when it comes to a trust. However, when you pass, the benefit of having a trust is that you don't have to go through probate because it's already placed in the trust. So your trustee will be able to take care of it as you see fit. Okay, so that is the benefit of having a trust, is that it's already taken care of in that situation. So the house is already under there. We normally don't like to put cars, but you know, again, that's up to you because we change cars so often, and you don't want to mix liabilities inside your trust. But again, houses, businesses, real estate really kind of fit into the trust mold. So when you establish a trust, it goes, your property goes into the trust. You will maintain the trust as the trustee of it, and upon your passing, then it doesn't go through court. Your trustee essentially either keeps it according to your wishes or dissolves it and disperses your assets amongst your beneficiaries. But that's how it's beneficial. It doesn't go through public. Again, a negative part of it is that it does cost a lot more, right? Because you're asking the drafting attorney to create a larger package with more contingency in this situation. And so, again, the work is upfront during your lifetime. Whereas a will is more simple because you just say what it is, whatever it is that you want, and then at the end, the administrator will take care of it.
Eric, got a question
Yes.
on the trust.
Mhm.
So the trustee can be anyone that you delegate, or
Yes, it can be anyone. So it can be a person, it can be a company. Usually what happens, and that's a great question, thank you. So usually if you are the first person, you're called the settler. And so the settlers normally act as trustees as well. Okay, so what happens is we'll say you and your wife are the trustees at first. Something happens to you, heaven forbid, then your wife will be the trustee and she can nominate somebody else to take over. So that's how you can go down the lineage on that line. And you can add beneficiaries at the end. What you cannot have is one trustee and one beneficiary and they're the same person, because you just cancel each other out. Right? So you have to have at least two on one side and one on the other. That's the way it is. Because if Calvin is the trust, you know, the trustee of your trust, if you're also the only beneficiary, then what's the trust for, right? Because you're just protecting yourself or you're holding it for yourself. And there's no trust in that. Does anybody have any?
Yeah, so I guess like if we have properties and that's under like an LLC, you can still put it in a trust. Like, is there anything like, how does that work?
So without kind of going too far into that, if an LLC is its own entity, right? So technically the LLC owns the property, so you can't really shift that property from the LLC to the trust, because you're just shifting legal owners. Memberships of the LLC is a different story. But when it comes to property, the LLC already owns the property, so it has its own protections under the LLC. Okay, that might be a good topic for future. Is how do LLCs work? How do memberships work? How does property ownership and community property? It all manifests itself into this situation. But yeah, what you're asking is a legitimate question: is what do I do with my company when something happens? All right, so we've talked a little bit about this before. Is considerations of estate planning, right? So first is what is your goal, right? If you're the kind of person that can handle maintenance, keeping track of all your assets as you move through life, then a trust might very well be in your benefit. If you're the kind of person that tends to forget things, or just wants to write something and then forget about it for a few years and then come back, update, then perhaps a will is better suited for you. But that's something that you would have to discuss with you, your family, or just kind of understand what it is that you want to do. There's nothing that prevents you from really having a trust and then a will as a backup. But again, that's something that you'll have to discuss with your estate planning attorney. But just kind of have to have an understanding of what it is that you want.
Which
Yes.
one takes precedence if you have a will and you set up a trust? Which one would be?
So really, if you can only give what you own. So if you have a trust and you put the property into the trust, technically don't own that anymore. So you cannot give whatever properties into the trust. So that's how it works. And
So like the cars could be in the will because they're more tangible personal property, and then the actual properties need to be in a trust.
right, so if that's the situation, then the trust would take care of the properties. And then the wills would take anything that you forget to put into the will or into the trust. And it would be divided out that way. So there's not really one that takes over the other one. They're just kind of who owns it at that point. So some of the things that you need to also think about is your family dynamics. So what we talk about is a nuclear family, right? So if you, if you have children, let's say you have children, spouse, and that is your only spouse for the remainder of your life. Well, that is one thing that is taken into consideration with your will on your death. Another issue that may happen is, let's say you were married, you create a will, something happens a few years later, now you're divorced, you get married again. You never changed your will. The problems that we actually have in previous cases in law school that we study is that the will said to my spouse, but never said what the spouse's name was. So now we have an issue as to which spouse are we talking about here? Are we talking about the spouse when the will was made? Or are we talking about the spouse that's current or the last spouse? So now you have an issue as to how these assets are divided. On top of that, if you have children with the first spouse and you name them, Calvin and Daniel. But then later on, you have more children, but they're not named in your will. Does that mean you specifically excluded your other children, or how is that going to work? So now you're having an issue as to what assets go where, who's supposed to be included in the will, who's excluded in the will. These are things that you will have to think about. Obviously, don't plan on divorces. That's not what I'm asking you guys to do. But have a plan for your current life right now. And then as your life progresses and moves up, don't forget to update your will. Okay? All your assets and your debts, that's something that you also have to kind of consider as well. One of the questions that estate planners ask is who's going to pay for your funeral expenses? Does it come out of the estate, or does the administrator pay for it and then they get reimbursed for your funeral expenses and costs, your last hospital bills, things of that nature? And then finally, planning on how your assets are going to be distributed. Now, again, if you have a will, it's going to be public record. So we don't want to list too many things. So we want to list the big things like the houses, if you are giving that to your family, or how it is going to be divided amongst your family. If you own, luckily enough, 4 houses, 4 kids, and each kid gets a house, then that's one way of doing it. But do we want to list all 4 houses in there? Or do we want a different kind of method, saying that, hey, each kid has a pick, kind of like a snake draft in a fantasy draft? So on one hand, we want to make sure that we are talking about your assets in a way that is understandable, but we also want to kind of keep an eye out for those fraudulent the fraudsters out there that are going to try to find ways to stick their fingers in there and try to defraud your family in the past. Now, I talked about this a little bit before, is what is the legal process when it comes to probating? So if we have our will, it is one method. If we don't have a will, then it goes another way. And so with the will, it's called testing. And the application portion of this is it's a little more straightforward than what happens if you don't have a will. So with a will, you will need the original copy, death certificate, because we need to make sure that you have indeed passed away before somebody tries to put your will through the court. There would be a hearing. You'll notify all the creditors. You'll file, the administrator will file an inventory, appraisement, and list of claims, or they can file an affidavit. In lieu of that, distribute the assets, close the estate. Sounds simple. It could take up to 6 months, take up to a year. Some of them have even taken beyond that. But those are, just different aspects, different issues that everybody has. If you pass without a will, there are more steps in it. All right, so it's not as simple as saying, here's the will. There's no issues with this will. Please approve it. Without a will, you will have to file an application for administration, meaning you want to open up the estate so that you can pay off the debts, distribute the assets. But you'll also have to do an application to determine heirship, which means we have to identify every single beneficiary out there. So when it comes to it, you might have 2 kids in this one marriage, you might have 2 kids in another marriage, and oops, you might have a kid that you totally forgot about, but that kid didn't forget about. So the state will have to take into consideration all of these issues. So it's never as easy as saying, I have 2 kids, or this person has 2 kids. Thank you very much. Let's distribute the assets. What the court will do is they'll have to appoint what's known as an attorney ad litem. That attorney's job is to go through the decedent's history and to make sure that there are no additional beneficiaries out there, and to try to essentially establish your claim of how many beneficiaries. They'll go through public records, they'll interview people, and so it becomes a larger process. During the hearing as well, you'll also have to find 2 independent witnesses to come and testify that they knew the decedent, knew the family history. Depending on where the court is, I know Denton County, they prefer somebody who knew the decedent for over 10 years. So you're going to have to find somebody that's over that period of time that will testify that they know the family well enough that they can really say he's been married or he or she's been married once, twice, 3 times. These are the only kids. And then go from there. So when you're going through the probate process, again, it takes time. And if your house, your property is listed and it's pending, it's going to take time before you can actually sell it. So it really helps when you know the entire process of this situation.
I have a question.
Yes.
What if you listed a home and the only seller that's alive had passed during the listing? You have to remove the listing because now it's property of the state since that person died. What do you do if it's on the market listed? And they die?
Right. Yeah, that would actually have to. Would most likely have to be updated to say that it's
In the state.
in a state, because that person's no longer allowed to sign. The person is now passed. So whoever the administrator of that estate is will have to take over. So we did talk about the consequences, or we are talking about the consequences of dying without a will, the potential family disruptions. Again, you're looking at the state without a will, you're looking at the state of Texas telling you how it works. You have the potential of having family disputes. Again, if you have an ex-wife and a current wife, although in this situation, the ex-wife wouldn't have any, but it would depend on whether or not you have kids. And as we look at this chart, and I'm sorry, this is confusing to say the least, but this is the clearest pie chart that I could find about this. So if you look at 1A, here, right here. Okay, so this is separate property. So when we deal about when you pass away, we do deal with community and separate property the same as we do with a divorce. Separate property is everything that you have before the marriage. Community property is anything that was occurred during the marriage. So in this situation, if the decedent passed away and had separate property, 1/3 of that separate property will go to, let me take a step back. It's separate property and the children are the same as, have the same. You only have children from the one spouse or partner. Right? So then 1/3 of your separate property goes to your surviving spouse, and then 2/3 of it go to your children divided equally. What happens to real property? Well, the spouse in this situation doesn't take any of that separate property. They'll take a life estate, meaning that they can live in the property. So if you have a house, they can live in the house for as long as they live or until they say, I'm done with it, but they don't actually have a claim to it. The children will take equally subject to the life estate. All right. When we look at the decedent's share of community property, so everything that was earned during the marriage. So how that really works, if you want to think about it, when a person dies, the community estate will be divided 50-50, right down the middle. So the decedent will own 50 and the surviving spouse owns 50. If all the children are from the surviving spouse, then the decedent's 50% will just scooch over to the wife or the husband. And that person will have 100%. Okay, so that's how it's literally divided into half. If you don't have a will, I'm sorry, I did something. Okay. If you don't have a will, pass away, go through the administration portion of it, and lo and behold, you have another kid. Another kid comes up, and that kid is not from your current partner. Well, then I'm sorry, spouse, you know, because it's you get it divided, right? So 50% here. Okay, so the 50% here, wife, you get it. So if we're going to talk about it in terms of money, So if the only thing you guys have is $100,000, wife, you get 50,000. Kids, you're gonna divide that amongst yourselves. And that's because you have, the state of Texas is going to take care of every single child that you have. So if you have a child that's outside of your partnership, or multiple children from outside the partnership, the current spouse, because it's community property, will only take their half, while the other side is divided up. So it's very important that that you guys kind of have that idea what happens without a will, because the state of Texas and the judges here are going to go by that. They're going to say, I'm sorry, here's your half, kids, here's yours. Divide it up that way. So it's very important that we kind of know how this situation works. And if you are selling property, you need to know who the signers are. Is it just the spouse? Or do now the kids need to get involved and all sign the documents as well? Something that we have to think about on that. Okay. And that's all I have for this side of the presentation. I'm about 35, 40 minutes. But you guys have any questions and we can get it in here.
A lot.
Question, so when you say children, does it mean only your biological children or children through marriage or through other marriage? So does it include your stepchildren?
That's a good question. No, it does not include stepchildren unless you specifically adopt them. Yeah, so,
Put in the will.
or in the will.
Without benefits.
If it's in the will, then that's where it works. What some stepchildren can do and what there has been case law as is kind of like a common law marriage, where if the decedent consistently says, this is my child, this is my child, this is my child, holds it out to everybody, this is my child, may have a chance. But as the law stands, stepchildren are stepchildren, they're not a part of the estate, so it has to be basically of the blood. It go through that way. And then, you know, it gets even more convoluted if you don't have any children, because then it has to go somewhere, so it goes back up the chain, so it goes up to your siblings. And if you have half brothers and sisters, well, then they take half. It just becomes a larger issue as to how do you trace who gets what, because again, the state doesn't, they want to divide your stuff up, they don't want to leave it into one bucket. Yes, sir.
Can you use a trust to defer pay long-term capital gains taxes?
And again, that's a question that you would have to ask a CPA. I know there are certain protections that you can have from a trust, but when it comes to those kinds of situations, I would ask a CPA on that matter. You don't want to ask me.
So I guess y'all, the CPA and you kind of work together though, I guess I could say like NACO here, like talk to the CPA with taxes, and that's something y'all write in the trust, or like, what is that?
It depends on the attorney. Some attorneys are, you know, they're CPAs or they're tax attorneys, and so they already have that knowledge in there. I don't. So what I normally do is I say, hey, look, talk to your CPA first. See what it is, see what the ramifications are, and then you come back and you tell me how you want it to go. And then I can advise you from that standpoint. When it comes for like taxes, I don't tend to touch those. But it is very important that you actually talk to us, even if your attorney says, you have a tax attorney, says whatever it is, I would still double check that just in case, because you don't want a big surprise at the very end of it.
Regarding surprises, like, I didn't know Calvin before 2008. So I don't know what he has out there in the world. I think there's a surprise.
Not that kind of fun.
Two questions. One, can the trustee take a a salary or whatever to manage the trust. And two, we had somebody, not in my little family, but in someone in our extended family, where they were supposed to manage the trust and come to find out they took money from the trust. So what ramifications, once a trust is put into place, all those records, are they like, you know, available for the beneficiaries to see? Do they have to keep records for so many years? So I know it's a bunch of questions, but
Right, and so in a general, so I can't specifically answer your kind of situation, but in a roundabout way. I'm sorry, my brain already lost your first, but your second
the
question.
cost of the
Okay.
court for probate, yeah.
Okay, so the cost of a trust, that's up to the settler. So if the settler wants to say, yes, the trustee can take however much, if they want to say $10 a month, they can say that in the trust. Now, will the trustee take it after that? Probably not, but most of the time, what I'll say is whatever is whatever the industry standard is, they can take it as their administration fee.
But it has to be written in the trust.
It has to be written in the trust, and that actually, it helps if you're turning it over to a company or a bank or a law firm that's going to administer your trust after the initial settlers die. When it comes to the actual enforcement of the trust, which is it's a very valid question, because if the settlers are gone, they're the ones that actually started it, so they care about it more. So let's say you turn it over to a bank and they don't even care about it at all. They're just hand it to the newest guy, and the newest guy fumbles around, does some other things with it. The beneficiaries can sue the trustee, and that is a breach of fiduciary duty on the trustee, right? So the trustee must act in the best benefit of the beneficiaries as long as the trust is in place. Where that comes into play is, you know, if for some reason the trustee says, you know what, I don't think we need these real properties, I think we need a Lamborghini. He sells all the properties and he buys himself a Lamborghini. As long as he can explain to the court, if he gets sued, why a Lamborghini was in the best interest of the beneficiaries, then it's fine. I don't think a judge will really buy that, but that's not for me to say. However, the beneficiaries can file that suit against the trustee if they feel like the corpus of the trust has been mishandled.
As far as the financial side, is there a requirement for them to keep those records within a trust for, you know, once the trust is set up, like, you know, they sell a house and they put the money in there, but then can they close that bank account? I mean, you know what I'm saying? You just,
Right, so
what are the stipulations? What are the rules of being a trustee?
Right.
Keeping records?
And so for keeping records, there's no hard and fast record that comes to my mind right now, but it is very much, you have to run it like a business. So you know, keeping records for 7 years, especially if you're selling assets in order to get to another asset, you have to keep records of that, because if you are challenged, you need to establish what happened, right? And it's harder to establish what happened if you say, oh, I don't have anything. And then it's hard to explain why this is in their best benefit if you don't have anything of record to show for it, right? So if you're shutting down accounts, but you can't show anything or where that money went to, as a trustee, I would be very nervous. Yes, ma'am.
Another question, so when you create a will when you're married, does it have to be signed by both parties or by both I guess husband and wife, or I'm trying to get it, if you create your own will and that might be conflict with some common law, you know, about the marriage, shared properties or stuff or something like that, which part would take the precedent?
So
Take high
that-
priority?
That's a great question. And for me, in my practice, I never do a joint will. Right, so each person has their own will. So husband and wife will have their own will, and really it's because you want to avoid conflict. If the husband says, I want to give everything to my wonderful son Calvin,
Yeah.
and Daniel gets $1.
Yes,
The mom might not be happy because Daniel might be her favorite. And she says, no, Calvin
Everything.
He's
gonna buy the Lamborghini.
He's gonna buy the Lamborghini.
Yeah.
So what ends up happening is like the husband and wife start arguing in the office. And that creates bigger troubles that might lead to a division of estate. So the husband will have their own, the wife will have their own. Sometimes what happens is both husband and wife show. And the husband will say yes, 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 and the wife will say yes, 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 yes. And as soon as they leave, they email me and say, no, I don't want that. Which is great, because then I can't tell anybody else. I just draft the way you want it. I just draft the way they want it. And that's really the best way to do it. The other problem with a joint will is that if you both don't die at the same time, the survivor can always change it because they're still alive. So that makes a big issue as well. So again, separate wills, always the best. And if you go into the plan thinking, okay, we're gonna do the same, but then change your mind, you don't have to tell your spouse. You can change it as you want. So,
Can
Good
you,
question.
for the sake, sorry, because if my will says that, yeah, I wanna leave this whole house, like, if we have two houses, I wanna leave both the houses to my children, for example. Sorry, the children 1, 2, 3, and then, but when I die and he doesn't wanna do that, what's he gonna do with these houses?
But they're legally married, doesn't have to go to the.
right, so you can only give what you own,
What you own,
right?
you're
So,
giving your half. But your spouse gets the other. That's what he was saying.
right, so then in your house, if you have one house, your husband would own 50%. And then if you have 3 children, each child would own 1/3.
Oh,
So you cannot give your husbands away because he's still alive.
so.
What's the difference between? I feel like I'm asking all the questions. The difference between an irrevocable and a revocable trust.
Oh, so it is what the name applies. When you have a revocable trust, you can say, I don't want this trust anymore, you can take it away. Or you can change it, you can do whatever you want with it. If you have an irrevocable trust, once you do it, it's set in stone. And the only way you can change it is to go before the court and get the court to actively revoke it. So there's certain tax reasons as to why you may or may not want to do it. Those tax reasons I don't know, but I do know that the recommendation is to not do a irrevocable trust unless you have a very solid reason as to why you want to do it.
If we have a living trust, we still need a will.
So a living, it depends on what you mean by living trust. So if you have a trust already, if you have your assets in there and you are continuously updating your assets, you most likely don't need a will, but it's always good to have a backup will just in case you don't transfer your assets into your will. Right, so if you buy a house and you forget to purchase it under your trust, then it's under your personal name. And then once you pass away, well, it's not covered by your trust and it'll have to go through the court. And at that point in time, you would go through intestacy laws and hopefully there's no surprises on that end. But that's the way it would go. So if you have a will to just kind of cover everything else, then at least you are. Yes, sir.
Just what you said, if you have a property which was not put into a trust, okay? But if a family member all agree to divide, no disagreement, you don't have to go to court.
Ideally, that would be the best.
Yes,
If your family all gets along and
Yes.
says, we're gonna divide it equally, I
Okay.
love you, no issues.
yes,
That would be the best.
yeah,
You may still have tax issues, you still have to go through a different portion of the probate procedures. You would have to do an application to determine heirship, so it's a longer time frame. My experience, however, is it doesn't really turn out that way.
Okay.
One sibling, probably all know who that is if we have siblings, will end up saying,
Calvin.
will end up saying, Mom and Dad love me best,
Okay.
so therefore I should get the most. Or one sibling will say, I'm the one that stayed back, ran the business. Why do you guys get an equal share? All of you guys ran away and did whatever you wanted to do, so I'm not gonna have that happen, and I'm gonna fight for it. There's an actual famous case where the children fought over a velvet Elvis painting that the father bought in Las Vegas. They spent the entire estate fighting over this painting or this picture because it was dad's favorite. So while you're alive, yeah, all the kids, hug each other, but once everybody has their own idea. So it's
It's rare.
yeah, it's never the best. I mean, it happens, right? There are siblings that say, okay, that's fine, we'll all go our ways, but more often than not, there's ones that don't do that. Yes.
So I guess two questions. You said, if we purchase a property on our name, without putting it in trust, you can still put it into trust after the fact, right?
Yes.
And then what does it look like when you say you're managing the trust, like just adding more properties in there? What does that really entail?
Yeah, so when you're managing a trust, again, it's like business. You have to keep the records and just pay the taxes, just kind of go through all of it. So it depends on who your beneficiary is, how that operates. But you can't let it go to waste, because whoever your beneficiary is, they say, hey, look, you sold that house and you bought a Lamborghini. While you might think it's great, it doesn't help them, and they're going to come after you, right? So you have to kind of keep an eye out on that. So you can't freely move as much as you want when it's not. You still have to do it in the best interest of your beneficiaries. Yes, sir.
Is there a difference between that the trust is created in California versus created in Texas?
The laws are different, but when it comes to saying, do you need a trust in each state? The answer is most likely not. One
So
trust is-
the trust in California does not stand in Texas? I don't get it.
Well, you would pass the properties, right? Because again, when you have a trust in California.
Yeah.
Well, it doesn't matter where you have the trust owns the property.
Yeah.
So the properties will be divided out amongst that trust. Now, if there's an issue that pops up, well, you would be suing in California, not in Texas.
What if a California trust owns a property in Texas?
Again, you would have to go with California, because that's where the property owner is,
Created.
although the land is in Texas.
Okay.
Yeah, I mean, you're really looking at a jurisdictional battle at that point in time. But it depends on whatever the trust says. Because the trust can say, any issue, you have to come through California. Or it could say, if there's any issue, you go to the state in which the property is located. It just depends on how your trust is made. But when it comes to it, you don't have to have a trust in every single one. If you move from California to Texas, you don't have to say, oh, I don't want this one, I want that one. It's up to you.
So whenever the issue happens, then that's the problem that we need to know which side of it.
You would have to refer to the trust, and if the trust is silent, then it would be a jurisdiction situation. Yes.
That's an extension for his question. Do people usually include the property outside of the US or only for US?
That makes it hard. I don't know the laws outside of the US. I mean, it very well could be the other countries say, I don't know what this is. I don't know how to read this, so I don't care what it is.
Okay.
It's very, very much so. From my experience, that a lot of countries, they might give you reciprocity, but they most likely don't.
It's just better.
Yeah, if you have clients that own property in foreign countries outside the US, I would suggest that they talk to an attorney about
within that nation.
within that
Okay.
nation.
Okay.
Because again, the US doesn't have any control as to what Peru or Mexico or anything else, any other country does with their money. Because if the US comes in and says, no, that's my citizens' land, they're gonna say, I don't care.
No, the citizen is US citizen.
No, I mean, that's what I'm saying. If the US goes to whatever country and say, I get this land because this paper says so, that country's gonna say, I don't care. You can't tell me what to do with my land. Is my experience in crypto. Yes,
They
ma'am.
need to try to figure out if he have a will in there. For that property. Maybe they can register, if they have a will in other country, they can register here with, or you can share with your attorney here. In order that they can provide, well, he have a will or trust here in the United States, and he have a will in Colombia and a will in Mexico, or.
No, the US law will not apply to other.
Yeah, but I mean, if you as a father buy a lot of properties outside the United States and you don't want to share that information with your child, you can have a will in that countries and share that will with your attorney here. If or a personal, I don't know, you can design whatever you want and say, okay, I have this will in that this country and this country and this country. If something happens, you can share that. Because it's not nobody going to.
Right. It's
No.
harder for people to find your property.
Yeah.
You've got to make it as easy as possible for everybody, which actually brings me to a good point. If you choose to get a will, do not put it in a safety deposit box. Because if you do and you pass away, right, that becomes a problem. Then
Yeah.
you have to go before the court and you have
Yeah.
to say, hey, judge, I'm pretty sure it's in there. Say, really?
Yeah.
And so now you have to get the convince
All
the
the
court
process.
to open it and only remove that. Because you cannot remove anything else because they don't want you to steal anything. And so that becomes a huge problem. So if you have a will, tell the administrator, the executor of who you have it or who is going to be with, where it is. So if anything happens to you, they can go and get it. If they go and get it and they cannot find it, the court will assume that you destroyed it because you didn't want it anymore. The administrator cannot come back to the attorney and say, I can't find the copy of the will. Can you give me the last copy? I can only say no. Now, if you find the copy and for some reason ink or something, I don't know, if we're back in the 1800s and you're using a feather pen and dump your ink all over it, if that happens, then I can be called to testify as to what the contents are, because you didn't mean to destroy it, it's just accidentally happened. But if it is gone, if it's in a fire, if it's in one of those things, then I'm sorry. Yes, ma'am.
I apologize if I missed this already. You talked about it. What's the life cycle of a trust? So if I create a trust, I put my assets in there and give it to my children, right? Or I name them as the trustee or
Beneficiaries?
beneficiary. But when I die, they take it over. And would that mean that trust is has accomplished and finished its goal, and then they don't need another trust? Or what's the end of the trust?
That's dependent on you. If you want it so that once you pass away, then everything gets distributed, then that would be the end of it. If you want it to last for generations, you can make it last for generations.
So that'll be part of the trust that
Yes.
I have to specify that when the trust will be, I guess, closed with the word.
Right, so for the most part, if you, when I write a will and they just say, look, I want it for generations, right, so. The language in there will be broad enough that it just continues on. And then the last trustee, whoever that is, will have the option to close it if it drops below a nominal amount. So if for some reason your descendants 3 generations from now spend everything and there's only $10 left in the bank account, well, there's no point in having a trust anymore, and the trustee can close it out at that. Other than that, then it'll just keep kind of going, and then they'll have to not have a plan as to who the trustees would be after one goes away.
So you have to sign a different trustees, right? Because trustee can be like 3 generations.
Yes, ideally it would be, but you know, the adding of a trustee is not really a problem. As long as it's set inside the trust.
So the trustee sign another trustee.
No, it would just be, yeah, it would be an amendment to it, saying,
Amendment.
hey, I'm the trustee now.
So
Like the Rockefeller,
You want now?
like at the Rockefeller family, that
Yes.
have that big trust. And
Yeah, they just keep going. And they're most likely run by a company, not a. One beneficiary.
And the title of the trust stays the same through the generations.
Mhm.
It'll change.
I've seen them where they do change names, they'll break into smaller trusts. But again, that's however. The settler wants to do it and how big their estate is. So there could be. You know, one person who breaks his into. One for each child, each of those descendant lines. Down that. But yes,
How long would it take the professional to set it up? 2 weeks, 2 months?
you know, it really depends on, one, the attorney workload. Two, how fast you can get us the information. Right, because if I say I can do it in 2 weeks, but you don't give it to me until the 13th day, then I can't do it in 2 weeks. Right, maybe 2 weeks from the time you give me the information, and then depends on how busy that attorney gets. But it's usually pretty rapid.
I think I establish my trust, just using attorney locally, they have a template. So they only change a small part of the wording, just fit your situation, they can do great fast.
Yeah, again,
A couple weeks.
it depends on, everybody is different. There are certain languages that we don't like to change. One of my professors says, or told me, you don't get extra points for being creative. Right, you want to stay within the law.
Yeah.
And that's how you protect your clients.
What is your company charged to do trust?
It really just depends on how large, and what you want to happen. But it can vary from. The low thousands to onwards, so just how much. How much you want us to do in every situation is different, but for us, we try to keep it as minimal as possible. I know there are some attorneys that do flat fees, and those are nice for certain situations, but you would have to kind of look at your assets. What it is that you. Yes, ma'am?
do all real estate and trusts, need to be paid off? Or does the loan can be a simple?
That's a great question. Certain loans will allow you to do it. But you would have to check with your lender before you do that. And it's very important that whoever the person is does check that loan, because if the loan does not have that clause, change hands, then that loan can be accelerated, which would create a lot of problems for you. But from what I've seen, the majority of loans that I've reviewed, they do have that caveat in which you can transfer it into a trust so long as you maintain control of that property. But again, you have to check the loan.
Can a trustee be the beneficiary?
Yes. Yes.
I've heard of what's called a ladybird deed.
Mhm.
How does that play a role in wills and trust and?
Uh,
Does that work?
So for everybody that doesn't, a ladybird deed is transfer on death deed. So really how those have kind of fallen out of favor now, just because again, they're also public record and you kind of see the lineage going down that line, but really upon death, it's just like, oh, I'm sorry, another thing to check up on is your bank accounts. Check your right of survivorship or your payable on death, make sure those are updated. There was a story in which somebody did not update it, and it went to their ex-wife. It was quite a bit of money. So check those, because those will go prior to any will, because you can only give what you own. If you have a transfer payable on death, on your death, that institution will change it over. So you no longer own it.
I don't have any biological kids, so I'm thinking about leaving my estate to my niece.
Mhm.
And, when I'm married, how does that come into play with my husband's kids?
So,
And I'm not adopting them.
right, so without kind of addressing your specific situation, what happens is if you choose to give it to somebody else, and you choose to give that entire estate to that person, whether it's separate, community, whatever, that's where it goes. So if you choose to say, hey, look, I'm gonna give it to my dog Fluffy, well then, dog Fluffy, you own it all. Kind of deal, and nobody else can say anything about it. So it kind of goes done that way. Yes, sir.
Yes, so if I die and I have trust and then I wanna pass my property to my son. And then they just change the title from title company or something.
Well, it's in the trust.
It's in the trust, your trust owns it.
Your
Trust.
Yeah, you don't own the property.
I don't.
So-
Okay.
When you have a trust, it's its own, you gotta think of it as an imaginary person.
Okay.
You just hand them the property, so now they're the owners of the property, you're just allowed to live there and tell them what to do with it. So when you die, they still own the property, it's just your kid kind of fits in your place.
So, but how my son can own the property?
That's the beneficiary of the trust.
Yeah, so if you want the trust to end. When you die, that's something that you would have to specify to the estate planning attorney. If you want it to continue on, so that it's for your son and your son's son and daughters and generations down that line. That's something else that you'll have to address.
So if that house in the trust, it will be in the trust forever until they terminate.
It depends on how you
Oh,
want it to end, how long you want it to be.
so if I don't have trust for anything, when I die, for my son get that one.
Or probate or will.
Probate or will.
Yeah,
And then how to transfer?
that would be up to the executor or the administrator of your estate.
Leave without will.
Right.
How hard is it if you own a house and you decide you want to set up a trust? How hard is it to change the title? To work with the mortgage company or thing to make it, or do you do that there, or do you just do it on the tax side?
Oh, no, that's a, the way it works is, it's not very difficult. You would just ask your lender, say, hey, I got it in a trust. Is there any issue with me transferring it over to the trust? They may say yes or no, but double check your loan and the deed of trust, because whatever that person says, even if they're like, yeah, no problem, go ahead and do it, but it's opposite of your deed of trust, that person's word isn't really worth it. So double check that. But let's say it's okay, you would just go to an attorney and you would say, I want to transfer this into my trust. They would draft you a warranty deed, file it with the court or the clerk, and then flips over.
So in my, in my case, no mortgage company have any disagreement. I didn't call them, but every year they receive the property tax bill. They can clearly see what of the trust. So no issue at all. As long as they have sufficient money to pay the tax. So
Well,
what you said.
I mean, yeah, in general,
Yeah.
from what I've seen from a lot of loans and deeds of trust, they don't have issue with you putting the property into
Right.
the trust because they do have a lien on the property.
Right.
So as long as they're getting taken care of, they're fine. However, on that one chance that for some reason, the deed of trust doesn't have that language, like the lender could be okay with it, but it just doesn't have that language. Well, now you're kind of stuck. Right? If they say, look, you don't have that language, so we're going to accelerate it. You're in a jam. So it's always best to check and not really depend on what happened in the past or normally it happens this way. Because yes, normally it does happen that way, but again, there's always that small % chance that it will happen, and that's when you're calling me and I'm saying, okay, well, you're right, but massive retainer down so that I can take care of it. Yes, ma'am.
One more question. This is something has happened to me and I want to prepare for a better solution for my clients. is that when a couple got involved in the accident and they passed away, unexpectedly, and they don't have a will, but they have a loan, a mortgage on their house. And what's the best way to protect the family and protect the house? Because last time when it happened, that the court took like 2.5, 3 years to finally put the house on the market to sell, but the mortgage kept accruing fines and, you know, interest and a lot, you know, it's like the whole thing just ballooned that they end up have to pay more when they sell the house. It's just a crazy, really sad situation. So what should we do as a realtor to protect our client, to advise them when this happens? What's the best way to do it, to stop, you know, that kind of clock saying, you know, what can we do
What-
about the loan?
Really, at that point. The best way to protect them is to say, hey, look, do you have a will? You have a trust, you have a plan. Because once you're into that situation in which one spouse passes away and there's a massive loan, there's not really much you as a real estate agent can do. It's really on the attorney side that's doing the probate and how that is working out. So there's a lot of other factors that go into that matter in which you're looking at a bunch of debts and independent administration. Sounds like you might have been in a dependent administration type of situation, which it just drags on forever. But really the best thing to do for your clients is to say, I think you should get a will, because this is a very large asset that you guys have, not anything that you can do willy-nilly. The debt is also very large. And so you need to have a plan as to what happens and try to avoid any kind of administration that doesn't immediately put an executor or administrator onto your property or onto your estate to help you essentially resolve everything. But once they're in the court system, that's unfortunately that's on to the attorney. And the attorney has to try to do as much as they can to mitigate it. But the courts are just full. And it just takes forever to get a hearing. Even if you try to get an emergency hearing, they're just saying, sorry, this is the first I got.
Well, if, for those that are in the XP, you know, our rev share organization is willable to our children or, you know, spouses, something like that. There is a document that we have to sign off in order to will it. So make sure that you go into the EXP site to find that document. I can find the link and send it to you guys. That's something that make sure that you guys do, because EXP doesn't know who to will it to.
Right.
And then of course also put that in your trust or will to kind of identify, like, yes, I have a organization, there's income, my position, will that,
And stocks, and
the stocks and everything.
will that continue on as far as rev share?
Yes,
to your-
yes.
Yeah.
So that is one of the benefits. If you don't know what I'm talking about, our position is willable, meaning that the income that your children will take that position. Maybe it's just one children, but then you can, in your will, you can say, this child will get it. However, it needs to be divided, whatever income from this. So you have to, that's where the attorney needs to write out more specific, whatever income from EXP, rev share, whatever, needs to divide that out.
It just,
Yes, 12, right now in the EXP policy, 12 funds are passing. That person that's supposed to be willable to needs to get their real estate license. So if you have children now, just kind of prepare them. If your goal is to build a organization, right? Some people don't, it's fine. But if you do, guess what? Prepare them. So they know what's going on, they know how to manage the team, connect with other people so they can continue that. It has happened. We had a friend that passed away from a fatal car accident. You know, immediately the spouse would have to get their license. And, you know, at that time, his organization was around 200. Today it's over 400 after him passing, just by growing. And that covers, so if you look at the calculation of the income, let's cover their his kids' college tuition. You know, so.
I was told that, that you would have to have like the LLC and the member of the LLC will need to manage it and that person, of course, would have to have their license. But it can be just your individual.
It can be individual, yeah, so that's why the attorney, when you talk to the attorney, you explain them like, hey, this is. Something that I have that that needs to be done, what's the best way, right, to manage that? Because if you have multiple children, how do you manage it? If it's the LLC, things like that. But there has to be a real estate licensed person. So it could be one of the kids or the spouse, whatever.
Yeah, and so I guess to wrap this up, I mean, I hope all you guys get, at least start thinking about having a will or a trust in place. But how it kind of ties back to this guy is that I can't help, although I can't advise you as real estate agents when it comes to a closing, but if you are closing with me, and give you kind of hints, tips, kind of timelines about how everything kind of situates out so that you can better prepare your client as to when the closing is, how the closing is going to occur, so that it can be a smoother process. So it does help to have somebody kind of know the steps that go in between, so that you're not showing up saying, we need to close next week, and it's like, it's not gonna happen because it's a deep in equipment, or that you're missing this step, you might want to ask about type of situation.
All right, how many think this is super helpful for you guys,
Yes.
right?
Yes.
Let's give, everything. I'm gonna have his personal cell phone and email address here. If you want it, come get it from me, I'll put it right here. But yeah, again, thanks, Terry, this is amazing, I
Thank you.
appreciate you,
Appreciate
yeah. So, yeah,
Thank you. And yeah, I got these extra notebooks. I think they're helpful. I use them for trials and whatnot.
Yeah.
So they have